Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue in the today's case is that if the assessee is a company who is incorporated in USA and if that assessee is providing the centralized services in the form of advertising and other hotel related services across the globe including India, and if the assessee do not have the permanent establishment in India, so whether that services that is in the form of advertisement will come into the definition of fees for technical services or fees for included services as per section 9 of the Income Tax Act and as per article 12 sub article 4 as per the double taxation avoidance agreement between India and USA. This issue has been taken up by the Delhi ITAT D bench in the case of Assistant Commissioner of Income Tax versus Sheraton Overseas Management Corporation. The date of the judgment is 13th Feb 2024 and the matter has been reported in 112 ITR Tribunal at page number 126. The present case relates to the assessment year 21-22. The assessee has filed a return of income of 16.35 lakh and claimed a refund of 1.52 crore. Since the refund was high and the ROI return of income was at a very less figure of 16.35 lakh, so the case of the assessee was picked for scrutiny under section 143 subsection 3. And during the assessment proceedings, when the assessing officer came to know about the nature of the services provided by the assessee, that is the centralized services in the nature of advertising and other hotel related services across the globe including India, the assessing officer was of the considered view that the services provided by the assessee come very well into the definition of fees for technical services and fees for included services as per section 9 of the Income Tax Act 1961 and as per article 12 sub article 4 of the double taxation avoidance agreement between India and USA. When the assessee was confronted with this show cause, the assessee said that the services provided by the assessee even in the remote cases do not come under the definition and character of fees for technical services, but the services provided by the assessee are in the nature of business activity and in the nature of business profits and which are not taxable in India because the assessee do not have the permanent establishment in India as per section 9 and as per article 12 of the double taxation avoidance agreement between India and USA. The assessing officer was not convinced with the submissions of the assessee, so he made the additions and calculated the income of the assessee at a very swollen figure of 33.63 crore. When the matter was heard by the CIT appeal was agreed with the submissions of the assessee and he gave relief to the assessee. So the revenue moved to the tribunal and the tribunal also said that in the present case from the facts and circumstances it is very clear that the services provided by the assessee do not come into the four corners of the definition of fees for technical services or fees for included services as per section 9 and article 12 sub article 4 between India and USA. And since the assessee does not have any permanent establishment, although the income of the assessee is in the nature of the business profits and business activity, so in the absence of permanent establishment, the income of the assessee cannot be taxed as business profits also. So the tribunal upheld the order of the CIT appeal. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Sheraton Overseas Management Corporation. And this case has been reported in 112 ITR Tribunal at page number 126, and the matter has been decided by Delhi ITAT D bench, and the date of the judgment is 13th February 2024. Thank you, friends.